If you're buying or selling a home in Illinois and you've never done it here before, there's a part of this process that is going to catch you completely off guard. And it doesn't matter if you've bought homes in 5 other states. It doesn't matter if you think you know what to expect. Illinois does something that almost no other state does. And if you don't know about it going in, you can either miss a window that was designed to protect you, or you can accidentally burn a deal that should have been fine. It's called the attorney review period. And in this video, the Caroline Gau team is going to walk you through exactly what it is, how it works, what your attorney actually does during those 5 days, what happens when attorneys disagree, how it overlaps with your inspection, and what this all looks like specifically on the North Shore in Northbrook, Glenview, Deerfield, Buffalo Grove, Highland Park, and the communities we serve and work in every single day. So whether you're a buyer who just got an offer accepted, woohoo, or a seller who just signed a contract, or you're just getting ready to jump into this market and you want to understand the process before you're in the middle of it, this video is for you. Let's get into it. Welcome to Living in the North Shore, Chicago channel. The Caroline Gau team is based right here in Northbrook, Illinois, and it's been helping buyers and sellers navigate the North Shore real estate market for 24 years. If you're new here, this channel is about giving you real, detailed, locally grounded information about buying and selling in this specific market. Not generic advice you could get anywhere, but the actual nuances of what it looks like to do this in Cook County and Lake County on the North Shore. Hit subscribe and the bell so you don't miss anything, because we put out videos like this weekly. Now let's talk about our attorney review. Here's the first thing you need to understand about buying or selling real estate in Illinois. Illinois is an attorney state. That phrase, attorney state, is something you'll hear a lot, but let's actually explain what it means. In many states across the country, real estate transactions are handled almost entirely by title companies and escrow officers. You sign a contract, the title company opens escrow, everyone does their part, and you close. Attorneys are optional. Most people in those states never even hire one. Illinois works differently. Here, real estate attorneys are standard, expected, and legally significant part of almost every transaction. Both the buyer and the seller hire their own attorney. Those attorneys review the contract, negotiate modifications, handle the legal side of the closing, and in some cases, actually run the closing itself. This is not an extra step or a luxury add-on. This is how Illinois real estate works. And the specific mechanism that makes Illinois so unique is this. After a contract is signed by both parties, there is a built-in window, a mandatory protected period, during which the attorneys on both sides can review that contract and propose changes, or cancel the deal entirely with no penalty and full return of the earnest money. That window is called the attorney review period, and it lasts 5 business days. Now we're going to go through all of it. How the clock starts, what each side's attorney is actually doing, what happens when a modification is requested, how this overlaps with the inspection, what the competitive market dynamics look like on the North Shore, and what to do if the deal falls apart during review. Let's take it one piece at a time. The attorney review period begins the moment both the buyer and the seller have signed the contract. That moment is called the date of acceptance, not when you made the offer, not when you verbally agreed on the price. The date of acceptance is the specific date and time when the last required signature was placed on the contract, making it fully executed. From that moment, the 5 business day clock starts running. 5 business days means Monday through Friday, excluding holidays. So if an offer is accepted on a Friday afternoon, day 1 is the following Monday. If there's a holiday in that window, that day doesn't count. You get 5 actual business days. Here's what the clock means. Both sides have until the end of that 5th business day to either approve the contract as written, propose modifications through a written attorney modification letter, or cancel the contract entirely. If neither attorney takes any action, meaning no modification letter is sent and no cancellations made, then the contract is considered approved and the attorney review period expires. You're moving forward as written. This is an important detail that a lot of people don't fully absorb. If you want to change something in the contract, your attorney has to act within those 5 days. The window doesn't stay open. And if you wait too long to get your attorney the contract, you can easily burn through half of that window before you've even opened the file. So the number one thing both the Caroline Gau team and your attorney will tell you is this: the moment you have an accepted offer, get that contract to your attorney immediately. Don't wait until tomorrow. Don't wait until Monday morning. Get it to them that day. The clock's already running. On our team, our transaction coordinator, Jenny, steps in to take over this process for us. Now let's talk about what each attorney is actually doing during those 5 days. On the buyer side, the attorney is reading the entire contract from start to finish. The multi-board contract, that's the standard multi-board residential real estate contract that most transactions use on the North Shore, is a detailed document. It covers the purchase price, the earnest money, how it's held, the closing date, what's included in the sale, the contingencies, the inspection timeline, the financing terms, what happens if either party defaults, and a long list of other provisions. The buyer's attorney is checking all of that to make sure the contract protects the buyer's interest, that everything that was verbally agreed upon actually made it into the written contract, and that there are no terms that could put the buyer at risk. In our area, agents work from that same standard multi-board contract we are all familiar with and use every day. As agents, we only fill in the blank, not modify the contract. The attorney review period is for that. On the seller side, the attorney is doing essentially the same thing from the other direction. They're making sure the contract is fair to the seller, that the earnest money provisions are adequate, that the closing date works, and that the contingencies aren't overly broad in ways that make it easy for the buyer to walk away, and that the seller's obligations are clearly defined. If either attorney finds something they want to change, they send what's called an attorney modification letter. This is a formal written document that says, in effect, my client agrees to move forward with this transaction subject to the following modification. The letter lays out specific changes to the contract language. Maybe they want to adjust the closing date, change how a repair credit is worded, clarify what personal property is included, modify an inspection contingency deadline, or add a specific provision around the home sale contingency if one is involved. Based on experience, there are usually standard provisions attorneys like to add to their letter. Rarely is there ever no modification. So you can expect to see a draft before your letter gets sent out. When a modification letter goes out, that stops the clock and triggers a negotiation between the two attorneys. The receiving attorney takes the letter back to their client, discusses the proposed changes, and either agrees to them, rejects them, or counter-proposes something different. The other side generally responds within a day or two. The attorneys go back and forth. Sometimes this takes one exchange, sometimes it takes several, until they reach an agreement both clients can accept. Here's something that surprises a lot of people about this part of the process. It's not adversarial. It feels like it should be because you have two attorneys negotiating and writing and there are stakes involved. But in practice, on the North Shore, this is usually a professional, business-like exchange between two attorneys who work in this market regularly and understand that the goal is to get to a clean contract both sides can live with. The Caroline Gau team has been through hundreds of attorney reviews, and the overwhelming majority of them resolve smoothly and quickly. That said, the key right that exists during the attorney review is that either party can cancel the contract for any reason during the 5-day window. And if they do, the earnest money is returned in full. No penalties, no questions asked. This is the protection the attorney review period was designed to provide. It gives both sides a chance to really look at what they signed before they're committed. This matters in practice more than people realize, and here's why. In a competitive North Shore market, and right now in mid-2026, this market is moving fast. Buyers sometimes make offers quickly. They might be in a multiple offer situation. They've got minutes to decide whether to sign. The attorney review period is the safety valve that lets a buyer make a competitive offer in the moment, and then in the days that follow, have their attorney look carefully at every line of that contract and make sure everything is actually okay. It's also worth saying clearly, if you are moving to Illinois from out of state, from Texas or California, from Florida or the Pacific Northwest, or anywhere that doesn't use attorney review, this is going to feel unusual to you. You're going to wonder why you need an attorney when you've never needed one before. And the answer is because Illinois law has made this part of a standard part of the process. And because having your own attorney review the contract before you're fully committed is actually a meaningful protection that buyers in other states don't have. The Caroline Gau team strongly encourages every buyer and every seller to take advantage of it. When do I have my inspection? Attorney review and the inspection period run at the same time. Let's back up. In Illinois, after your contract is accepted, you also have a window to conduct a home inspection and submit written inspection objection. On a standard North Shore transaction, transaction, that inspection window is typically 5 business days as well, though the exact length is specified in the contract. During that window, the buyer hires a licensed home inspector. The inspector walks through the property and the buyer reviews the report. Here's what most people assume. They assume attorney review happens first, then the inspection happens. That's not how it works. Both clocks run simultaneously from the date of acceptance. The 5 days you have for attorney review and the 5 days you have for inspection objection are, in most transactions, the same 5 days. What this means practically is that you are running 2 very time-sensitive processes at once. You need to get your attorney the contract immediately. You also need to schedule your home inspector immediately. And ideally, both of those things should happen before you even make an offer, meaning you should have your attorney's name and number ready to go, and you should have a home inspector you trust who can get to the property within a day or 2 of acceptance. The Caroline Gau team will make introductions to inspectors and attorneys who are trusted professionals. The attorney's job formally begins once you have an executed contract. That said, if you have questions before you even write the offer, a good attorney can help there too. Either way, time is of the essence to get these providers lined up. Let's talk about the inspection specifically, because it interacts with attorney review in ways that matter. When the home inspector completes their inspection, they produce a report. On a North Shore home, we're typically talking about homes priced anywhere from $600,000 to well over $1 million. That report can be 50 to 80 pages long. It's going to cover the roof, the foundation, the HVAC system, the plumbing, the electrical panel, the basement, the attic, windows, doors, drainage, anything else the inspector observed. A thorough inspection report on a North Shore home almost always finds something. That's not the sign of a bad house. Homes have systems age, and an inspector's job is to document everything they see. The question isn't whether there will be items in the report. The question is which items are significant enough to address. After reviewing the inspection report, the buyer has the option to submit written inspection objections to the seller. These are items from the report that the buyer is asking the seller to address, either through repairs before closing, a credit at closing, or some combination. The seller then has options. They can agree to the requests, they can decline them, or they can counter-propose something different. Here's where you need to understand the competitive dynamics of the current North Shore market, because this matters a great deal right now. In a market where homes are receiving multiple offers selling quickly, which is exactly what's happening in Northbrook, Glenview, Deerfield, and across the North Shore in mid-2026. Buyers who are competing hard for specific homes sometimes structure their offers to be more attractive to sellers by limiting or waiving their inspection requests. Some buyers offer to do a no request or information-only inspection, meaning they conduct the inspection for their own knowledge, but agree in advance not to ask the seller for anything based on what they find. Others accept the results of the inspection as is unless there are specific major safety defects. This is a strategy. It's a meaningful concession that sellers notice in a multiple offer situation. And the Caroline Gau team will help you think through whether it makes sense for a specific property, specific price point, and specific competitive situation. It's not a strategy for every home. A 10-year-old home that's been recently updated is a different risk profile than a 50-year-old home with original systems. But knowing that this lever exists and understanding how to use it strategically can be the difference between getting the home you want and losing it to someone else. What the inspection does not do, even in a competitive market, is go away entirely. Even when buyers waive the right to make requests, they almost always retain the right to conduct the inspection itself. Knowledge is still power. You still want to know what you're buying. An as-is agreement is about what you can ask the seller to fix, not about whether you get to look. You still look every time. Let's talk about what happens after the attorney review and the inspection are resolved, because there are more steps between the end of that first window and your actual closing date. After the attorneys have signed off on the contract, the balance of the earnest money is due. Once the attorney review period has closed, meaning the contract has been approved either as written or with modification, and once the inspection objections have been resolved, the transaction moves into the next phase. This typically includes the appraisal, the financing process, the title work, and for most North Shore transactions, sections of village transfer tax process specific to the municipality where the property is located. Let's start with the appraisal. If you're getting a mortgage, and most buyers are, even on the North Shore, your lender is going to offer an independent appraisal of the property. The appraiser's job is to determine the fair market value of the home based on comparable sales in the area. The lender uses that appraisal to make sure they're not lending you more money than the house is actually worth. In a market where homes are frequently selling at or above asking price, and where the competitive bidding environment sometimes pushes prices higher than most recent comparable sales can support, the appraisal is a point of real tension. If the appraiser values the home at less than the contract price, you have what's called an appraisal gap. Here's what that means for you as a buyer. Your lender is going to base your loan on the appraised value, not the contract price. If you agreed to pay $820,000 and the home appraises at $790,000, your lender will only lend against $790,000. That $30,000, the difference has to come from somewhere. You have a few options. You can renegotiate the purchase price down with the seller. You could bring additional cash to cover the gap out of pocket. You can challenge the appraisal if you believe it was done incorrectly, or if you have an appraisal contingency in your contract, you may be able to walk away. In the current North Shore market, some buyers in multiple offer situations are writing in appraisal gap coverage clauses, meaning they agree in advance to cover a certain amount of any appraisal gap rather than requiring the seller to reduce the price. Again, this is a strategy conversation our team has with buyers regularly, and it depends heavily on the specific home, the price, and the buyer's financial position. The financing process itself is running in parallel with all of it. By the time you have an accepted contract, you should already have a pre-approval. But a pre-approval is not final loan approval. After acceptance, your lender begins the full underwriting process. They're going to verify your income, your assets, your employment, pull your credit again, and review the specific property you're purchasing. Now let's talk about title. One of the steps in an Illinois closing that surprises people who come from other states is the depth of the title work. A title company in Illinois researches the entire recorded history of the property to make sure the seller actually has clean, clear, marketable title to what they're selling you. They're looking for things like outstanding liens, unpaid judgments, easements, restrictions, tax problems, estate issues, or other clouds on title that can affect your ownership after you buy. If a title issue is found, it needs to be resolved before closing. Most title issues are routine and can be cleared relatively quickly. A lien that was already paid off but not properly released, for example. But some title issues are more complex. Your attorney and the title company work together to resolve them. And in some cases, the closing date has to be extended to allow time for that resolution. You will also purchase title insurance at closing. There are two types in Illinois, one that's purchased for the lender and one that's purchased from the seller. Now, here's something specific to North Shore transactions that people from outside this market are often not prepared for: the village transfer tax or municipal transfer tax stamp. Northbrook, Glenview, Deerfield, Highland Park, most North Shore municipalities have their own local real estate transfer tax on top of the state and county tax. The seller is typically responsible for the seller's portion, and in some municipalities, the buyer pays a portion as well. The specific amounts vary by municipality. In some communities, the transfer tax stamp process has to happen through the village itself and involves a physical stamp or certificate that gets recorded at closing. On the North Shore, this step can add time and coordination to the closing process that people don't always anticipate. Your attorney, title company, and our team are all coordinating to make sure the village transfer documentation is in order before the closing date. But if you're planning your timeline and your moving dates, know that this is a step in the process. Before closing, the buyer has a chance to do a final walkthrough of the property. It's typically done within 24 to 48 hours of the closing date. The purpose of the final walkthrough is not to do another inspection. It's to verify that the property is in the same condition it was when you made your offer, that any agreed upon repairs have been completed, and that nothing significant has changed since the home inspection. Then you close. Closing in Illinois typically happens at the office of the title company or at your attorney's office. Both sides, the buyer and the seller, usually close at the same time or in close sequence. Your attorney is there with you. You're going to sign a significant number of documents: your loan documents from the lender, the closing disclosure, the deed, the title insurance paperwork, the transfer tax documents, and more. Your attorney will explain every document you're signing. After everything's signed, the funds are wired, the deed is is recorded and the keys change hands. That's it, you've bought a home in Illinois. So to recap, Illinois is an attorney state. Both the buyer and the seller hire their own real estate attorneys, and those attorneys are actively involved in reviewing and negotiating the contract and handling the legal side of closing. The attorney review period begins on the date of acceptance, the date and time both parties have fully signed the contract, and runs for 5 business days. The inspection period runs at the same time as attorney review. Our team helps manage this entire process. We'll be with you every step of the way. If you got questions about the attorney review period, ask away. This is what I do. Caroline Gau with the Caroline Gau team. Bye for now.